Hi, this is Jacqui Brauman here. This is a presentation that I did on the 15th of April 2016 to the Sunraysia CPA in Mildura. I thought I'd record the main points so that anyone can listen to it. My presentation was very much surrounding succession planning because that's my primary area of practice, and we're looking at family business dissolution and family farm dissolutions through disputes. And the best way for a dissolution to happen is by agreement. So if there's been an effective succession plan put in place and anything goes wrong, then all the better. So while it's ideal for an exit plan to be considered at the beginning of a business relationship, it's often not what happens. Often not much attention is given to how the business will end when new business partners come together in the excitement of starting a new business. Similarly, with a farm, the end's not usually considered, and the farming business relationship often develops over a period of decades and potentially isn't treated as a real business. So I'm going to bounce around a bit between the documentation that should be in place for your clients with businesses and hopefully prompt you to do some more business planning with your clients. But also we're going to consider situations where the planning hasn't been done and some methods to use to resolve disputes. It's always cheaper to put appropriate documentation in place first in case of a dispute rather than deal with the dispute later. So these agreements are the first documents that I will ask to see from a client who comes to me with a dispute or comes to me to do succession planning. The constitution of the company is important because what I'll look at is how the shareholding gets transferred and who has powers to appoint directors. A shareholder agreement is important, but often a lot of shareholders in a company won't have one. Same with unit holder agreements in a unit trust. These documents cover a lot of the situations that would be covered in a buy-sell agreement. If there's a trust, then the trust deed's really crucial. I look at who holds what power and what role. Particularly important is the appointer or guardian and how those powers are passed. Whether the powers are passed through deed or will, or whether they're automatically passed down to children equally, or whether they pass to the legal personal representative. So all of this stuff is relevant to look at. For partnerships, a partnership agreement's not necessary for partners to operate as partners, but it would be ideal if one was in place, because otherwise there is nothing other than the Partnership Act which determines how the partnership works. The Partnership Act is not great. If a partnership is dissolved on the death of a partner under the Partnership Act, or an administrator is appointed because a partner has lost capacity, or cannot perform their obligations, then the property is supposed to be split in accordance with the partner's interest in the partnership. But if that hasn't been agreed on between the partners, then you've got a dispute straight away. Most partners would probably say that it's a 50-50 partnership until it comes down to the crunch, and then they argue about who contributed what. And finally, the buy-sell agreement. So this can be part of a partnership agreement, it could be part of a shareholder or unit holder agreement, or it could be a standalone document. It's triggered by certain events which would dissolve a business relationship that was in place. So a bit more on the buy-sell agreement. The two primary goals of the buy-sell agreement, the first being to plan for the death or total disability of one of the partners and how the surviving partner continues the business in that situation and what the outgoing partner's family is entitled to in terms of compensation. And the other primary goal of the buy-sell agreement is so that the ongoing partner has control over whoever they do business with in the future. So the buy-sell agreement would deal with how the business is to be valued in a split, how the share or interest is actually transferred, how the transfer is funded, and what the triggers are for the entry or exit of partners. This also includes where one partner wants to leave or retire other than when there's a dispute. The remaining or continuing partner would often want to keep the business going, so they have to be able to afford to buy the existing partner out, and there needs to be a way of working out what that fair value would be to pay. If the existing or the exiting partner, has someone else interested, like a third party, in their share in the business, the remaining partner also wants to control who they work with. If they don't want to work with this new third party, there has to be some way of refusing to sell or passing on, or requiring the third party also to buy the other share out. So basically the buy-sell agreement covers many of the worst case scenarios, but makes a dispute much easier if one can be put in place. Ultimately, a fair outcome for everyone is best. Fair should be objective, not what the client necessarily thinks. Unfortunately, there always has to be a compromise in a dispute, and there can also be consequences if parties aren't dealt with fairly. So particularly in a company structure where a minority shareholder is oppressed under the Corporations Act, action can be taken to wind the company up, which is not necessarily what the continuing partner wants. So coming back to the documents that should be in place, we need to have a look at, when we're preparing such documents, whether the parties want to have a provision that all decisions need to be unanimous, or whether they're by majority, and such documentation will also need dispute resolution clauses. Whether something can be viewed as fair or not often depends on the situation between the parties, such as the capacity to borrow funds or buy out an exiting partner. It'd not be fair if an exiting partner knew full well that the other partner couldn't buy them out and was forced to sell the whole business. It should also be borne in mind that both parties should have independent legal and business advice, so that they're both properly informed to make a decision. This slide lists some of the triggers for the exit process that would be built into a lot of agreements, but also gives an indication of how disputes arise that would cause a business breakdown. So if a trigger arises, it's all good and well if there's a process agreed in place to follow, but what happens when there's a dispute and one party is basically forced out without any way of solving the problem? When there's such a dispute between farming brothers, for example, that no longer get along, the difficulty can be when it's not in the interest of one of them to resolve the dispute because they're continuing along just the way they want. Well, there's an interesting process that you can take to VCAT, particularly when land is owned. Well, in fact, only when there's real estate owned. Although I don't love court proceedings and litigation and would prefer to solve things the other way, sometimes you need to create some leverage so you can bring both parties to the table. Otherwise, there's no way of resolving the dispute if one party doesn't want to resolve the dispute. So, the fastest and easiest proceedings to commence the joint property proceedings in VCAT, and there's a number of remedies available there. So VCAT can force the sale of any joint property. It can force one farmer to buy the other out, for an independently determined value, and it could order for property to be sold and determine a reserve price. So resolutions can be quite creative in VCAT. It's usually one of the best outcomes, because during mediation you can also include a lot of other issues such as plant, equipment and stock, and deal with it all at once. If the parties can't resolve it, it's taken out of their hands and a VCAT member decides. So one way or the other there's a resolution. Where there's no land and no written agreements, it can be one of the most difficult situations. Obviously, if you've got a company structure, you can potentially go down the path of oppression proceedings. If there's a partnership without a partnership agreement, then look at the Partnership Act to see whether there's a breach and whether there's any damages that might arise. But it's harder to find leverage in these situations. So sometimes we're lucky when we deal with farmers. Some of the mechanisms for resolving disputes. These can be built into buy-sell agreements or other documentation, or they can be used as a negotiation tactic to resolve a deadlock dispute. So an internal auction can be used where the parties agree that they can't stay in business together anymore, but neither wants to sell the business. So they have an internal auction where each makes a bid to buy the other partner out, and the highest bid wins. There, it's a silent bid. A Russian roulette arrangement is similar to an internal auction, but it's an open bid. So one party offers to sell their share of the business to the other. The other refuses but has to come back with a higher price in reverse, and it's locked in one way or the other. So both these arrangements would favour a party who had deeper pockets than the other, which can be an issue of fairness. A compulsory sale to a third party is an arrangement where the entire business has to be sold after a certain period of time if they can't resolve their dispute otherwise. You'd often have to have an arrangement in place where a third party came in to run the business so the goodwill isn't depleted until it's sold, and an independent broker is appointed to sell the whole thing. So these three arrangements can be included into agreements. The following bottom two, however, can only be included in written agreements. They can't be used as part of negotiations. Tag-along clauses are useful to protect a minority. So if a majority partner wants to sell to a third party, the third party can be forced to buy the minority shareholding as well, because the minority doesn't want to stay and work with someone they don't want to work with. A drag-along clause works the opposite way, protects the majority. It makes it more attractive to a third party coming in because they don't have to be stuck working with someone they don't want to. So the majority shareholder has an attractive package to sell because the minority has to be included. Valuing the business. So parameters have to be determined about how the valuation's actually performed. Often you'd negotiate that the value to be used would be the average of two independent valuations that each party organises. But each of the valuations also has to be conducted on the same basis, so it's like for like. So there are some parameters that need to be agreed before any of that can happen. So the earlier the better for succession planning. Try not to leave it until a dispute happens. Accountants are the professionals that see people every year at least, if not quarterly. So they're the ones to bring it up with clients. Other things for farming and family businesses to think about: if they can't agree to a succession plan, try and get them to at least agree to a sunset clause, 5, 10 or 20 years when the business will be put on the market and sold if an agreement on succession isn't reached by then. Make sure you make provisions for a dispute, and they agree who they would appoint as the third party in that situation, so that the business can keep running if they can't work together, so that the value of the business is not lost in the meantime. Consider what triggers they want in a buy-sell agreement, and perhaps consider incentives to be built into agreements so that a partner would voluntarily leave before they became a drain on a business. And always consider how to fund a buyout. So we come to funding buyouts. Obviously, it's different where the business or farm has been broken up between the parties, and that they each take particular assets, although there's often have to be a cash exchange to balance out what each party gets. But in the situation where one party continues in the business and the other is completely out, there has to be ability to pay out the other. The method for the buyout could be included in the terms of a predetermined buy-sell agreement, or it could be part of negotiations to resolve a settlement. Common funding would include a loan from a third party if finance is available, potentially vendor terms, so the outgoing party is gradually paid back by instalments, or depending on the circumstances, insurance could be used to fund a buyout. So coming to insurance, insurance would mainly apply to a buyout where a partner has died or where a partner has become incapacitated. So the policy would be a life insurance or key person insurance or total and permanent disability insurance. I'd recommend not to have the partners insure each other's lives because this could cause a capital gains event. Policy should be personally owned where possible. However, this would have to be linked with an agreement that each would acknowledge that that insurance policy was to fund the buyout, so that you didn't get a situation where a spouse was paid out after the death of one and she then also went for further compensation. Also avoid the business actually owning the insurance policy. They could pay it, that shouldn't be a problem, but we don't want a situation, particularly in a company structure, where there's some kind of share buyback, that the company owns the policy to be able to fund the buyback, because that would change the cost base for the continuing partner. Also be careful if you want the policy owned by a trust or a self-managed super fund instead of an individual. This is because the any buy-sell agreement wouldn't be binding on a trustee of a trust, and you're not sure what how the trustee would treat that insurance policy. In agreeing to an arrangement to have insurance, there would also have to be an agreement about how often that policy was reviewed, so that it would reflect the increasing value over time of a partner's interest. We don't want a 10-year-old policy that wouldn't be adequate compensation. So in closing, don't forget that when working with farmers, there is more stamp duty and capital gains concessions than with small businesses, so you can be a little bit creative in how to resolve a split. But to try not to be a broken record, without initial agreements in place that deal with all these aspects, it's reasonably foreseeable that exit scenarios end up in at least an arm wrestle, if not worse. Families and friendships break down irretrievably. Standoffs can ruin businesses in the meantime. So the emphasis really is on succession planning. It's good for our businesses, and it's really good if it's done well for the clients as well.